And guys, some of this may bore you to tears. I know most of us, we ain't concerned about no history, but we're going to talk. What we're going to do during this part of the workshop is we're going to talk about trust and talk about their origin and the benefits of trust. And basically, I can sum this up. Trust law developed in England back in the 12th and 13th centuries. Pretty much, guys, back in that time, they had what was called the feudal system in England. And basically, you know, you had what was called a Lord Chancellor's Court, all right, that decided matters. And in that time period, when a landlord left England to fight in the Crusades, he needed someone to run his estate in his absence. And often he would pay and receive feudal dues. And so basically, guys, what you would do was, if individual was going to have to go off and fight a war, he might grant his property or convey his property ownership to a friend to manage on his behalf until he returned. So, hey, I'm going off to war. I need you guys to take care of stuff, look after everything for me, and, you know, I'll see you when I get back. Well, he would give the property to the friend, and then when he come back, just like a friend, they want to act like they don't know you no more and don't want to give you your stuff back. It's like I said, just like a friend. All right. So unfortunately, back in that days, English law didn't recognize the Crusaders' claim. So they formed what was called, and as far as the courts were concerned, the land actually belonged to the trustee, the person that they actually gave the property to. So the Crusader really had no actual legal claim. So basically what the Crusader would have to do, being disgruntled, they would have to go see and petition before the king, who referred the matter to the Lord Chancellor. And basically what the Lord Chancellor would do was determine who had just and equitable right to the property. And he also had the power to decide a case. All right. And so basically, guys, what would happen during this time, and I don't want to even go through all of that because y'all ain't concerned about it. But what I do want you to know is that this is where equitable interest actually was created and formed. Trust law basically came to the United States a great number of years ago, and actually the trust was actually originally formed and originated in Illinois, and that's where we have what's called Illinois Trust. So in Illinois, they have, you know, basically they are very familiar with the trust laws, and they actually know, probably that's one of the states where you actually have individuals that understand trust. So as we get into this part of the presentation, I'm going to tell you there are a number of states that are very favorable toward trust. The one exception is actually Louisiana. Louisiana comes up under a different type of system, and so, you know, I really don't have any knowledge of what they actually do in regards to trust, but trusts aren't officially recognized in Louisiana. Basically, in the U.S., they formed something years ago called the UTC, and that's the Uniform Trust Code, which was actually adopted by all 50 states, although Louisiana does its own thing. And basically the purpose of the Uniform Trust Code was to kind of try to standardize the law governing and around trust to the extent that people could know and understand what the heck he was doing with them. All right. And so the thing that I want to tell you about a trust is that in most cases, we have looked at this as something for the affluent. All right. Something for people that have a lot of money. You know, everybody else, most of us go around, you start naming trusts, we don't know nothing about that and don't care, because we think we have a will, and, you know, we just get a will and think that will is the be all end all. And what I said previously from the start is that with a will gets probated, okay, and you may or may not get all that you wanted or what your intent followed. So like I said in the beginning, you may want little Johnny to get $100,000 upon your death, and now maybe there's an attorney working with the executor of the estate, and that attorney's on the clock, and maybe his fee is, you know, whatever it is, a flat fee or 15% of the estate, and now you want little Johnny to get $100,000, and little Johnny gets $90,000 because the attorney got $10,000. Whereas if you had a trust, then that trust actually, because you can name a successor beneficiary, if you decease, then the individual, the successor beneficiary, steps right into your shoes. Okay? All right. So September 2016, 31 states, to include the District of Columbia, adopted pretty much the Uniform Trust Code in substantive form. All right. Trusts are actually these creatures of contract. They are creatures of contract, guys. Trust is nothing but black ink on white paper. That's basically what it is. It's just a contract. All right. And trusts are written, they must have a purpose and intent. All right. Virtually all trusts are what they call inter vivos trusts. Inter vivos meaning that they were created while the settler or whoever's creating the trust, also called the grantor, is living. Okay. Also, inter vivos versus testamentary trust. A trust created in one's lifetime, that's the inter vivos trust. Okay. Latin word meaning for living trust. Virtually, like I said, all trusts are virtually living trusts. A trust created when someone dies or upon someone's death is called a testamentary trust. All right, a testamentary trust. And so most of us know we're creating a trust, going to be an inter vivos trust, because we're creating them while we're living. And so we're trying to get our tax plans together. Matter of fact, see here, we got a turkey coming in. He's trying to get his tax plan together right before Thanksgiving. He said, basically, with Thanksgiving coming around the corner, I thought this would be a good time to revise my estate plan. And so this is a good time for you to start thinking of and revising your estate plan, because you need to have a plan for your estate. Guys, you know, this is not just for the affluent, it's for all of us. We just have to educate ourselves in the process. Trusts are basically, there's a couple of different types. There's a number of different types of trusts, and a couple of trusts I'm gonna talk about right now are revocable versus irrevocable trusts. All right, revocable meaning that the settler of the trust has the right to change or terminate the trust. Irrevocable meaning that they can't be changed or terminated by the settler. All right. We're going to be talking about, for the purpose of this workshop, our primary focus is going to be on land trust. Land trust. So we're going to talk about land trust and personal property trust. A land trust has real estate as its only asset. A land trust has real estate as its only asset. If you're not writing in your living room or wherever you're at, you need to be writing. Make sure you're taking notes. Land trust has real estate as its only asset. So you can't put anything else in a land trust. All right. So let me say one other thing. Oftentimes, guys, like I told you before, after tomorrow evening, 5:30, whenever we wrap up, you're probably going to know more than about 75–80% of the attorneys you come in contact with. That's not a slight at attorneys. That's just the way it is. They don't pay attention to this unless you're dealing with attorneys that deal with estate planning for the most part. So when you start talking about land trust, a lot of times what I told you earlier about when the eyeballs start spinning around, we don't do that stuff, or whatever. We don't understand nothing about that. They're going to tell you about what you can't do. Well, we don't even know about that. We don't even honor that. I don't believe that we even have state statute that supports that. So when you have someone that seems to be confused, instead of calling it a land trust, and to narrow down confusion or minimize confusion, just say a grantor trust, a grantor trust. Basically what we have is we formed a grantor trust. And it's funny because I can tell you, with me doing this, oftentimes when I'm talking to attorneys, it's funny to me. I'll go in there and I'll start talking about land trust, and I'm seeing their face and I can read the body language. I know they don't know what the hell I'm talking about. And so you're trying to do what now? Oh, well, basically what we're trying to do is we're setting up a grantor trust, and we're trying to deed a couple properties into the grantor trust. And then, oh yeah, sure, I know how to do those. So all of a sudden they understand, because they understand grantor being in the trust. Okay. Grantor is just simply, guys, the creator of the trust. All right. So the grantor is the person that actually creates the trust. A trust has a trustee who administers and manages the trust and its assets. Administers and manages the trust and its assets. All right. All right, then you have the beneficiaries of the trust. The beneficiary of the trust is the individual who actually is entitled to receive the proceeds and avails and the benefits of the trust. That's the beneficiary. All right. Also, as a part of a trust, you may have, this is optional, you may have what's called a director. And a director administers directions to the trustee. Why would we need a director? You might need a director if you had like a minor child or someone that was incapacitated and the trustee wasn't handling all the business and you wanted to appoint a director to actually manage that minor child or incapacitated person's interest in that trust. So therefore you can adopt and utilize a trustee. All right. So what do we have with the trust? With the trust, what you actually have is a trust agreement, that contract that we talked about, that I spoke of earlier. So you have a trust agreement, which is recorded. The deed to the trust is recorded. The trust agreement is not. Put it on me, Dave. The deed to the trust is recorded. The trust agreement is not. Listen to what I'm saying, because you're going to have some screwball attorney tell you, we need to go down here and we need to record this trust document. Heck no. Shake his hand, tell him thank you for your time, because he don't know what the heck he's talking about. You do not record the trust agreement because your trust agreement is a private document. It stays with you. You don't want everybody knowing your business. You're going to record just the deed. The purpose of the trust is anonymity, estate planning, and asset protection. While I'm right there, let me say this one thing. Never, ever go and start talking to people when you start talking about trust and your asset protection plan. Don't start talking to other individuals about, I'm trying to get my asset protection together. I need to get an asset protection plan. I went to the Tony Robinson Senior Workshop, and he said I needed an asset protection plan. You don't tell somebody that you're trying to protect your assets, because they don't care about you protecting your assets. All right? Listen to what I'm saying. Don't start referring to it as an asset protection plan. This is the language. Listen to me closely. This is the language that you want to use. When you're talking to somebody, you go talk to them and you say that I'm working with my estate planning attorney, or I'm working with an estate attorney regarding my affairs. And basically what I'm trying to do is put together my estate planning. I'm trying to put together an estate plan to manage my assets. Estate plan. Y'all see how that sounds? Estate plan. Again, don't start referring to, I'm trying to do asset protection, because ain't nobody trying to protect. Ain't nobody want to hear about you, particularly depending on what situation you're in. Nobody wants to hear that you're trying to protect your ASS. So they're trying to talk about, so asset protection, forget about that. Estate plan. All right. So with the trust agreement, you also have a deed, which I talked about. All right. Again, the deed is recorded. The trust is not. All right. So you're going to deed your property to the trust. Y'all follow me? Deeding your property to the trust. Now, I'm going to go ahead. I was going to play video, but we'll go ahead this way. I'll do it just like this. So what we're going to do, guys, because I can show you this, I can show you better than I can tell you. So basically what we're doing when we do a trust, what we're doing first of all is we're creating a trust agreement. All right. I want to simplify this as much as possible so you understand. So in that screenshot, well, in the screenshot, you knew we had a trust agreement. Don't worry about it. So you got a trust agreement that you created as the grantor. So you're forming your trust. And in this particular case, what we're forming is a land trust. Everybody see. So with this trust, we have paperwork and documentation. We're forming our trust agreement. So basically what we're doing is we're going to deed our property, because the property is in our personal name or whatever. So we're going to take our home, right? We got our home, and we're going to deed our property. All right. And maybe our home is on 123 Main Street. And in this case, just for simplicity, for this demonstration, I'm going to say we're deeding our property. We're John and Sue Smith, and we're deeding our property into the 123 Main Street Trust. So we put our property in the trust. Boom. All right. Now we're going to go downtown and we're going to record the deed. That's the only thing that gets recorded. We're recording the deed. Our trust agreement that we talked about is private. That stays with us. And no, you ain't entitled to it. You don't get it. Don't let nobody tell you they get your trust agreement. No, you're not privy to that. You're going to have some lenders. You're going to have some banks. You're going to have some attorneys. You're going to have some closing people tell you, well, we need to see the whole trust document. No, you don't. You don't get to see that. That's a private document, okay? So they don't get your trust agreement. All right. So you deeded your property into the trust. I want you to understand something. Once you deed that property into the trust, you no longer own the property. Listen to me closely right here. When you deeded that property to the trust, you no longer own the property. The trust owns it, okay? The trust owns the property now. All right. You are a beneficiary to that trust, and you're entitled to the proceeds and avails of that trust. Everybody with me? I'm trying to keep it simple so we get it all the first time. All right. So now what I want to do is I want to talk about the players. I want to talk about the players. Who's involved in this box Tony talking about? So what we got? We have the players. We got the trust agreement. We have the deed. We got a trustee. So what we have to do when we form our land trust, guys, is we have to appoint a trustee. All right. We have to appoint a trustee. Who's the trustee? The trustee has to be someone that you trust. Y'all remember that example where the gentleman was going out to fight the war and come back, and his friend didn't want to give him property back. Okay. So someone that you trust. Okay. Now, typically when we're doing land trust, we can do a company that we're the owners of. You might have a friend. Okay. You know, several investors, all you guys that are in Facebook groups and whatever. Maybe you have somebody that's in another state that's the trustee for you, and you're the trustee for them. Okay. So somebody that you trust, because this trustee has the power and authority to sell your property, to do a lot of different things. Okay. But the thing that you have to remember is that they cannot do anything without the written direction of the beneficiary. If they do anything other than what the beneficiary directs them to do by writing, then they are in violation of their fiduciary responsibilities to the beneficiary. Okay, so they're working for and on behalf of the beneficiary. And that's the beneficiary that you see depicted on the screen. So the beneficiary is entitled to the proceeds and avails. And then, of course, optional, you may have a director. So like I said, if you had a minor child, someone that was incapacitated, whatever, they weren't able to, they might be the beneficiary of the trust, but they're not able, or maybe they're not mentally capable, or maybe, you know, they're 12 years old, they're not ready for that. Then you would have a director directing the trustee on behalf of that minor beneficiary, okay, to the trust. All right. What can be in a land trust? A land trust assets include raw land, single family houses, apartment complexes, warehouses, shopping centers. Okay, that's what you can have in your land trust. All right. Now, benefits of a trust. The trust transfers assets without probate. That's the most important benefit of a trust. I told you guys that earlier, and I'll demonstrate that here shortly. It gives you asset protection because nobody knows who owns it. All right. So if you're riding down the street, deal machining and land gliding and prop streaming and everything else that you do, and you get up there and you see the 123 Main Street Trust, you don't know who the heck that is. Okay, you don't know who owns it. So it provided you with a level of anonymity. It also, and that anonymity gives you a bit of asset protection through privacy. Let me preface this and let me make sure that it's clear that you don't get asset protection through a trust. And asset protection does not come from the trust. Let me tell you right now, just because you set up a trust gives you no asset protection. It gave you anonymity. As the trust itself provides no asset protection. None. So make a note of that. It provides no asset protection. What gives you asset protection is if you put your property in a trust and have a LLC as a beneficiary of the trust. Now you get your asset protection through your LLC. Okay? A trust individualizes each property. So that breaks down and componentizes actually each property. Individual, a note for reference, one land trust, one property. We're not putting 4 and 5 properties in one trust. One land trust, one property. One land trust, one property. All right. So putting that property in land trust gives you privacy. It gets your name off public record. All right. Beneficial interest in your land trust can be sold without transferring title. That's the point right there for me to stop for a second. All right. Because what I want you to understand something, and Dave, you can put them on me full. When you take that property, and you guys pay attention, I want you to look at what I'm doing now. And some of you may have seen this on some of the posts that I made. When you put your property in the land trust, okay, remember what I said. When you put your property in the land trust, now the trust owns that property. All right. Not only does the trust own that property, whenever you put property into a land trust, residential homes or single family residential homes is called real property. That's its category and status. Real property. When you put property into a land trust, it converts real property into personal property. You need to be writing if you're not writing where you're at. That converts real property to personal property. That means it's no longer real estate. It's no longer real estate. Understand what I'm telling y'all, because this is key. And I'm getting ready. I'm going to tell you right now, y'all need to be sending me an offering. If I don't get no offer, I'm going to be mad. Because this right here done paid for your $1,000 right here. I'm just telling you, you can talk all you want to. You already got your money's worth. If I stop today, they unplug everything and we go home. That converted real property to personal property. That's significant. It's significant in the fact that now that it's personal property, that means it's not real estate anymore. Well, Tony, why in the world is that significant? It's significant in the fact that now I can actually take this personal property that I own and I can sell or assign my beneficial interest. Remember, when I put that property in a trust, I am the beneficiary of that trust, 100%. Now, I'm going to sell my beneficial interest to someone. So I give my beneficial interest. I say, hey, do you want to buy? You want to buy my land trust, which happens to have a house in it as its only asset. So basically, I'm selling you the 123 Main Street Trust. So I'm selling you a trust that just happens to have a house in it. What does that mean? That means that privately, I have sold you a property. And let's just say I told you I'm going to assign my beneficial interest to you, and you can take over my trust for $40,000. I'm going to do assignment of beneficial interest. You're going to give me my $40,000, and now this is your land trust. Okay? This is your land trust now. I want you to understand. So, this is that person's land trust. What's significant about that? He now is the beneficiary of that trust. Guess what? I sold that property to him for $40,000. Nobody went downtown and told nobody nothing. Guess what else? Y'all look real close. Y'all look real close. Guess what else? None of y'all raggedy nuts heads out there know nothing about the deal. A property has been sold and nobody knows nothing about it. And I ain't telling nobody, and he ain't telling nobody. That's privacy. Guess what? He can take that same trust and decide he wants to sell it to somebody else. Now the property has changed hands 2 times, and nobody knows what happened. Nothing being recorded even at the courthouse. Nobody knows. Why is another reason why that's significant? Y'all books, you should be writing real good right now because I'm giving it to you. This is diamond after diamond, nugget after nugget, just in case you didn't know. Now, what other good benefit of it is this with that property? This. I told you guys about Dodd-Frank. Now, you can get sophisticated as you want to or not. I'm just going to make a statement and then we're going to keep moving. Dodd-Frank came out back in 2014, I believe. And maybe 2010. I'm getting my years. I'm getting old, y'all. Anyway, when Dodd-Frank came out, they limited our ability to be able to sell property. Okay? And do seller financing. What if, let me ask you a question. What if you wanted to finance a property to somebody and you sold them the beneficial interest in the property on installment contract? Did y'all hear what I just said? If you ain't listening, you better pay attention. I'm selling somebody my trust on an installment contract. I'm not selling them real estate on a contract. See, if I sell them real estate on a contract, then I'm having to deal with Dodd-Frank law. I'm having to do 43% debt to income ratio, ATR, which means ability to repay. I got to make sure I got to do all this stuff even that the bank is required to do in certain cases. But I'm not selling them real estate. I'm selling them personal property. This is no different right now than me selling them a car and financing it. Okay? So I just got around some rules. Now you make sure you get in where you fit in and you get all the details on how to do it and make sure you are protected. But now you sold that property on installment sale and you're making a boatload of money and nobody knows what you're doing. Matter of fact, in some cases you can sell it on installment sale and basically you can have their tenancy basically is you can sell it in a manner where basically they have more or less a tenancy interest in that property for all practical matters. And so now we're talking eviction versus foreclosure. Woo! Y'all better listen to all this stuff right here. Okay? So now we can take this, and I'm getting ahead of myself, but I'm gonna come back and clean it up. So we formed our land trust. Everybody with me on forming the land trust, right? And so the next thing we want to do, like I said, the land trust in itself provides no asset protection whatsoever. It provides a level of anonymity. My asset protection comes when I take my LLC, which is represented by this box here, ABC Rentals LLC, okay? And what I'm gonna do is I'm gonna make ABC Rentals LLC the beneficiary of my land trust. And now, guess what? Now I have asset protection through my LLC. Everybody still with me? Now, next thing. Let's just say I'm paranoid because based on some of the questions that I got from you guys, some of you guys are paranoid. So let's do this. I've created my land trust. All right, we've created our land trust. And now, class, what did we say? We say when we put that property in the trust, we converted real property to personal property. Now that it is personal property, I can have the personal property be owned, or the beneficiary of the personal property can be another trust. And that trust is called a personal property trust. So the beneficiary, I'm going to form a personal property trust, same type of documentation. So I form the personal property trust. I make an agreement for the personal property trust. Personal property interest does not get recorded anywhere. So you don't have to record anything for that. So now I'm going to, by bill of sale, I'm going to place my land trust into my personal property trust. And now what I actually have is 2 levels of protection. No anonymity, but 2 levels of protection. So my land trust is owned by my personal property trust, and then my personal property trust is owned what? The beneficiary of my personal property trust is my LLC. So now you have 3 levels of protection. Y'all see all that going on? So now we have 3 levels of protection. And my personal property trust, which has a land trust in it, has asset protection from and through the LLC. Okay, now let's clarify one other point, because you'll have some crazy attorney tell you can do this. A land trust cannot own another land trust. Write that down. A land trust cannot own another land trust. Why? Because a land trust only asset can be real property. So if you converted real property to personal property, that negates you being able to have a land trust own a land trust. So the only thing that can actually own or be a beneficiary of your land trust as a trust-wise is that personal property trust. Okay? This stuff is sweet stuff, guys. This is good stuff. Because the thing I like about this is that it gives you a level of anonymity because, number one, it takes your footprint off public record. Takes your footprint off public record. I want you to understand this. When you're out here buying and selling properties, particularly if you're taking possession of properties in your name, okay? So or even in your company name, say you're buying real estate and you're closing on these deals. You're closing on these transactions. ABC Properties, bought a house and sold a house. ABC Properties, bought a house and sold a house. ABC Properties, you bought a house and sold a house. So let's just say you're doing 4 or 5 transactions a month. And ABC Properties, buying a house and selling a house. ABC Properties, buying a house and selling a house. Guess what? If you're making a footprint like that, I want you to understand something, guys, that real estate, every time you get a property, every time you have a property deeded in your business name, personal name, or whatever, you have left a footprint that will be there as long as they're keeping records. Somebody can go back to in 2050 and see that you own that property in 2012 or 2020. Okay? So what I'm trying to tell you is that if you're doing a lot of deals and you're actually buying these things and taking title, then what happens? What did I say earlier? I said that the bird with the brightest feathers gets shot. So if I'm a real estate investor doing asset search, if I'm a real estate attorney, or if I'm a plaintiff's attorney doing an asset search on you, and I go to the public record, and it looks like, my God, this guy, cash money for houses, he's doing some business, right? He's doing it up. You look like you got some money. You moving and shaking. because your footprint is on public record. Now, if you buy properties and take title to your properties that you buy in a trust, that means that when you contract that property by virtue of your purchase and sale agreement, and you have on there that ABC properties and or it's assigns or whatever, y'all put that language in there, but that's all crap anyway. As long as there's nothing in the contract contrary to you being able to assign the contract is assignable anyway. All right. However, sometimes I like to put it in there just so that it's clear, but it's not required. Unless it says that it's not assignable, the contract is assignable. So now that you have, you may have done your contract in ABC properties, but then before closing, you're going to call your closing attorney and you're going to, or title company, and you're going to tell them that we're taking possession of that property in a trust. By the way, the name of the trust is the 123 Main Street Trust. And now when you take possession of that property, right off the bat, your name is off public record. Your company's name is off public record. You never were on public record in any way, shape, or form. And so you can form a gazillion trust forever and ever, amen, and nobody knows anything about what you're doing. Now, how many people think that's sweet? You should be in your living room shouting and dancing, because I just gave you the keys to maybe keeping your name off public record and looking like you ain't doing nothing. Although some of you ain't took your game out the box yet anyway, but you're gonna get it out the box after this weekend. All right. So now, when you put that land trust, when you take possession in that land trust and you have your deed, all right, I said you had your trust agreement and you had your deed. The other thing that you're going to have, and I just want you to write this down, we're going to get to it, you're going to have what's called a certificate of trust. Everybody follow me? You're going to have a certificate of trust or a certificate and affidavit of trust. That certificate and affidavit of trust, guys, is going to be recorded with your deed. Listen to what I'm saying, because this is important. You need to be writing. I said you need to be writing. When you record your trust from the beginning, you want to right behind the deed, when you record your deed for the trust, right behind the deed, you want to record a certificate and affidavit of trust. Okay? You're going to record that certificate and affidavit of trust right behind the deed. So you're going to have your deed, which may be a 2-page document, and then you're going to have your certificate of trust, which may be a 1-page document or a 2-page document. And that certificate and affidavit of trust is going to talk about all the stuff dealing with the trustee, and pretty much that's it. Okay, and we're going to talk about that in a little bit. All right, so that's it. Now, you go to sell that property, just getting you straight already. When you go to sell that property, you're going to have all kinds of misinformed attorneys and title companies and everybody else call to tell you, well, we need a copy of your trust and all this. We need your LLC operating agreement and all that. You might send them the LLC operating agreement if you're the trustee. You send them that so they can see you're operating in good faith and standing in your state and all that stuff. But they don't get the trust. You tell them there's a certificate of trust that's filed behind the deed if you look. Because most of the time they'll just look at the deed on the first couple of pages and they don't even look at the certificate of trust. And if you send them anything, you send them the certificate of trust. Now, you have to look at your applicable state law and statutes. For instance, where I'm at in the state of North Carolina, our general statutes basically say that the only thing that's required is that certificate of trust. That satisfies, because that individual, whoever is certifying and giving that affidavit, is certifying that that trust is valid. Okay, so you don't get the trust. You don't get to read through it and see everything that everybody's doing or not doing. So just telling you that right now, because you're going to have banks and title companies and whatever ask you about that. All right, so I think I simplified that as much as I probably could simplify that. Let's move on a little bit more. All right, so benefits of the trust. it gives a division of assets by naming successive beneficiaries prior to death. So in your trust document, you're able to actually name who the successive beneficiary is. All right. So if, you know, the beneficiaries of the trust are John and Sue Smith. If John predeceases Sue, then Sue becomes, she gets his 50% beneficial interest if it was split 50%. All right. One of the benefits of the trust is that you get to be the manager and not the owner. And this is a message to all of us investors that like to go out, because I can tell you when I first started in this business, I was real proud of myself. I wanted everybody to know I owned everything in the world. Okay. But you don't want to own jack. That's the whole purpose of you having the trust, is so that you're not owning anything. So it's easy when you have something in trust. If you have to go out there and deal with the tenant, you're the manager. You're going out there as the manager. I'm representing the trust interest. I'm the manager I'm the manager for the trust. Who's the owner of it? Well, who's that person? That's none of your business. You dealing with me as the manager. And see, when you're the manager, it makes it easy for you to deal with tenants. Because if you have a tenant in the property that's telling you, want to be complaining, talking about they don't want to pay this and don't want to pay that, you can go over there and you can carry the big stick, but you're still just the message carrier, because you're going to be saying, well, Miss Johnson, I know, you know, if it was up to me, I wouldn't have you pay a dime. But that darn Tony Robinson crazy as I don't know what, and I want a job, because if you don't pay, he gonna fire me. So that's why I'm out here to collect rent. All right. So it makes it easier for you to deflect. Don't, you know, one of the whole things about asset protection, guys, is that you're trying to appear broke. You don't want everybody to know that you're rocking and rolling and that you control and have all this stuff. All right. So I told you already that it converts land into personal property interest. There is no separate tax return. All right. So Dave, if you'll put it back on me a second again, I want you to demonstrate. So guys, when you took possession of that property in the trust, all right, the beneficiary, a trust is a flow-through entity. This is a flow-through entity. It flows through to the end beneficiary. All right. So if the beneficiary of my trust was this LLC, then guess what? The LLC files the tax return. The LLC files the profit and losses on the LLC's tax return. All right. There is no, listen to me closely, because you're going to have some ignorant, incompetent attorneys and whoever tell you that what's the trust identification number, or what's the EIN number for the trust. This trust requires no EIN number. Number one, because it is a revocable trust. In some cases, if you have a revocable trust, you may have to get its own separate tax ID number. But this is a tax ID number is not required. It flows through to the beneficiaries. So if John and Sue Smith own this, or were the beneficiaries to this LLC, to this trust, then the proceeds and avails would flow over to their individual tax returns. All right. If it's the LLC, it flows over to the LLC's tax return. All right. So it does not require, nor does it generate a separate tax return. All right. It has no relationship with state government or annual fees or whatever to set up. All right. So you don't have to go and start trying to file something with the state because you have a trust. All right. That's important in itself. Okay. Because let's go back again. Put them back on me one more time, Dave. So you buy a property. You live in Florida, and you want to buy a property in Ohio. Okay. Technically, if you're buying that property as a rental property in Ohio and you live in Florida, then you're going to need to do an LLC in Ohio because you're going to be doing business in Ohio. All right. Now, to get around that, if you bought the property in trust and your Florida LLC is the beneficiary of that trust, that LLC is not operating in Ohio. The trust is. Y'all better send me another check, because some of y'all are doing stuff from state to state, and you paying all of these fees to form your companies there. Matter of fact, I know California, $800 to do LLC. Okay, so send me my darn $800. Anybody out here from California, send me my darn $800. All right, so anyway, that's a benefit. That's another benefit to the trust. Next thing. All right, why one property per trust? Because it segregates the asset individually. It also limits your exposure and liability, and it protects your asset from conflict. All right. The other great thing, guys, about a trust is, let's just say inside your trust agreement, it's going to outline everything in regards to that trust. And you can set up partnership agreements with the trust. Okay. And what did I say earlier about doing partnerships? Basically, we don't want to do partnership, but you can actually take a property. I want y'all to see this. Look at this, because this is important too. Let's just say you and one of your friends decide you want to buy a property together. And so what you're going to do is both of you are going to share, let's say you're going to be 50% beneficiaries each. What each one of you can do is actually form your own individual personal property trust for your 50% interest. Okay? So each one of you has a personal property trust that owns 50% beneficial interest in this trust. Okay? And in your personal property trust agreements, it's going to prescribe everything as to your agreement. Everything as to your agreement. And like I told you guys, anytime you're entering into a partnership with anybody, you want to make sure that you discuss all of those D's up front. And I told you the D's this morning. I said the D's are why you're happy, why y'all glad to get in this agreement. You discuss all the stuff that's going to happen if something goes south. What happens if somebody dies? What happens if we have a disagreement, disillusion, disgruntled, disinterested, whatever it is, all those D's are discussed. And so what happens is, guys, the trustee's responsibility is to manage that trust on behalf of the beneficiaries. That's important, because in that trust agreement, you and your partner in the deal might be fighting. Matter of fact, y'all can't stand each other now. But the trustee has a fiduciary responsibility to follow that trust agreement and do what that trust agreement says. That just helped you out. For some of y'all that's out here doing agreements on handshakes and whatever, go ahead and take up another offer and send that my way too, because that just told you how you're going to deal with that. All right. Again, I said it limits your exposure to liability and protects your assets from conflicts. I just demonstrated. All right. You're also able to fracture interests of multiple owners without being partners. That's where I just showed you about doing it through personal property trust. All right. The trustee has no personal liability. He has no personal liability, but he has a fiduciary responsibility to manage that trust property and trust interest on behalf of the beneficiaries. Okay. And he's doing that by written direction. If he does something without the written direction of the beneficiary, then guys, you might see him going out with his hands behind his back because he's committing a crime. All right. Legal and equitable property interests in trustee's name are on the title. So with a land trust, the trustee has legal as well as equitable title in that trust property. All right. Again, I already stated this earlier. There is no requirement for a registered agent because you're not filing anything with the state and all that good stuff. All right. So there's also no partition. So that means that it avoids spouses' forced share sale upon divorce. It's not partitioned like that. Okay. You got a trust agreement that tells you how you deal with matters of disagreement and whatever. All right. No cost upon transferring to a beneficiary. So as I demonstrated earlier, if you're selling that property to somebody or selling that trust to somebody, there's no transfer tax. There's no cost. Now, you may, you got to be, if you're actually buying the property that actually was a transfer, you can decide how ethical you want to be and go down there and tell your local county tax office. They'll be glad to let you know that you came to advise them that you took interest and write me a check or write them a check. All right. It's ease of linkage to other asset protection entities. I already demonstrated that your LLC is linked to that trust, and therefore you have your asset protection through your LLC. No tax return to file because it's a pass-through entity. All right. And a question that might be asked, can I still buy real estate with my IRA using the land trust? You actually absolutely can. Your IRA can invest in the trust. So you can buy real estate through your IRA. All right. And basically what's going to happen is your IRA is going to be the beneficiary of the trust. All right. Now, this is a demonstration of what I actually talked about earlier. You had an Ohio land trust, and the beneficiary of that Ohio land trust is your LLC. And in that illustration right there, your LLC is located in North Carolina. You weren't required to register or have an LLC in Ohio because your trust is doing business in the state and it's not required to be registered. And it's still drawing asset protection from your North Carolina LLC, who is not actually doing business in the state. The trust is. Okay. All right. Now, some things that a trust does not provide: no protection from foreclosure. All right. The lender still has the right to secure their interest in that property by virtue of foreclosure, should you not make payments. So it doesn't stop a foreclosure if there was a loan on the property. All right. Because remember that the trust is just responsible for the deed, is not responsible for the note and the note and mortgage on that property. The deed of trust. The borrower will still be required to settle the debt or litigate in court. So basically, the borrower doesn't get out because you actually formed the trust. Okay. No protection from repossession. So if you formed a personal property trust and you put your car in the personal property trust, because a car would be personal property, then again, same thing. They still can come and find you in your driveway and go jack, and haul you on off. Okay. So it doesn't give you any protection from that. All right. So trusts are generally governed by federal law. However, it is important that you acknowledge specific state laws and guidelines related to the trust. All right. A trust does not protect against damage to real property or provide coverage to fix your vehicle in the event of an accident. All right. A trust will not protect you if the asset is stolen. All right. Because it only holds title. Now, the thing I want to say again, right there, guys, is that I want you to understand one thing, and put it back on me, Dave, and then we're going to take a break after this part. All right. So I want you to understand something. I said earlier, because this is a mistake that a lot of people make. You put your property in a trust. Many of you, after this workshop, you may want, if you own your rental, your personal property, even your rental properties, you may decide that you want to put your property in a trust. So if you put your property in a trust, say it's your personal residence, once you deed your property to the trust, you no longer own it. Listen to me closely. Y'all see that? You don't own that. You're a beneficiary of it. And title has changed hands. Title is no longer in the trust. Title is no longer you. The title holder is no longer you. The trust is the title holder. So I want you to get this right, because if you screw this up, you might mess up something for real. Number one is that you have to change the insurance once you put the property in a trust. The insurance has to be changed because the trust owns it, and the trust is the title holder, not you. Your insurance is based on the title holder. All right. So you put your property in a trust, and then the house burns down. Insurance companies are good for two things. Listen to me closely right here. Insurance companies are good for two things: collecting premiums and denying claims. They love to collect premiums. They love to deny claims. So you want to make sure that you change the insurance. So if you put the property in a trust and it's the 123 Main Street Trust, you need to call your insurance company and say that you want to insure your trust. And we're going to talk about that in just a little bit. But you're going to have to change the insurance to your trust, okay? All right, so we're going to take a 10-minute break right here, and then we'll come back and keep moving. So let's take 10 minutes, guys. Go stretch, bathroom break, whatever you need to do, and we'll get back right on it in just a little bit.